Offshore asset concealment in bankruptcy, hiding wealth in foreign bank accounts, foreign real estate, offshore trusts, and international business entities is a serious and increasingly scrutinized form of bankruptcy fraud. Here's the investigative framework for identifying and pursuing offshore assets in bankruptcy proceedings. The disclosure obligations are clear. Every asset the debtor owns or has an equitable interest in, anywhere in the world, must be disclosed in bankruptcy schedules. A Swiss bank account, a rental property in Mexico, a foreign trust, or shares in a foreign corporation are all required disclosures. Omitting them is perjury on the bankruptcy petition and federal bankruptcy fraud. The evidence trail that reveals offshore assets typically begins domestically. Wire transfer records, visible in bank statements that can be obtained through discovery or court process, show transfers to foreign accounts and identify the recipient financial institutions. Tax returns reflect foreign income, and FBAR filings, required for all U.S. persons with foreign accounts exceeding $10,000, must be disclosed. FBAR and FATCA as investigative tools. U.S. persons with foreign accounts are required to file an FBAR annually with FinCEN. These filings are not publicly accessible, but in litigation contexts, discovery, IRS cooperation, or criminal investigation, they provide a definitive list of foreign accounts. FATCA requires foreign financial institutions to report U.S. account holders to the IRS, creating a separate government record of foreign financial relationships. International bankruptcy coordination. In multinational bankruptcy cases, the principles of Chapter 15 of the Bankruptcy Code govern the recognition of foreign bankruptcy proceedings and cooperation between U.S. and foreign courts. A U.S. bankruptcy trustee seeking assets in a foreign country typically works through the court systems of that country, using available legal assistance mechanisms, including mutual legal assistance treaties. Real property abroad. Foreign real estate appears in foreign property registries, typically less accessible to routine investigation than U.S. county recorder records, but accessible through professional investigative partners in the relevant jurisdiction. Property transfers from the debtor's name to foreign entities in the period before filing are recoverable through the same fraudulent transfer principles that apply domestically. People locator skip tracing coordinates with international investigative specialists for offshore asset matters. Visit peoplelocatorskiptracing.com to discuss your investigation needs.